This is the Law y La Ley, a podcast on the Constitution and the Supreme Court from the perspectives of scholars of color. I'm Craig Jackson, a professor of law at the Thurgood Marshall School of Law at Texas Southern University, along with Professor Ediberto Romano of the Florida International University School of Law in Miami, and Dr. Laura Cisneros, affiliated scholar at the University of San Francisco School of Law, coming to you today from London. This was the final week of a momentous term of the Supreme Court, and over the next several weeks, we will be going over the latest decisions of the court that will have already are having major impacts on social, legal, and political life in this country. Today, we start with one of the cases which is universally considered to be the big one from this term. It is the Birthright Citizenship case. Trump versus Barbara took on the question of whether President Trump could, by executive order, reinterpret the Citizenship Clause of the 14th Amendment to exclude from the grant of birthright citizenship those children born to parents temporarily or not legally in the country. By a vote of 6-3, the court decided that Trump's executive order could not alter the understanding of the meaning of the Citizenship Clause, but only by a vote of 5-4 did the court hold the executive order unconstitutional. That was because Justice Kavanaugh did not join the court on the constitutional issue, finding instead that the executive order violated federal statutory law. Justice Clarence Thomas wrote a dissent, as did Justice Alito, and Justice Jackson wrote a concurrence to the decision. Now, Eddie Berto has been writing and advocating on this issue for quite some time, so he's going to be having a lot to say about this case over the next few minutes, next hour or so. So we're going to start, however, with our own perspectives about the case, and we go for. I just want to mention also the fact that, given the fact that this case has to do with birthright citizenship and immigrants coming to the country, that the name of our podcast was named by Eddie Berto, the Law y La Ley, basically representing the kind of diversity that we think is important in our country's history and our country's present day. And so we get a chance to talk about that because it seems so fitting that on the 250th anniversary of our country that we have this birthright citizenship decision and the way it came out. So I just kind of gave you a glimpse of my opinion about it. But Laura, what are your thoughts about this case to start off?
Okay. So again, 194 pages. Thank you. But honestly, I couldn't put it down. The case for me isn't simply about history versus text or originalism versus living constitutionalism, because every one of the opinions uses history. So what I started to kind of look at was the disagreement, which is essentially over what history is supposed to be doing. And it's about these competing theories of constitutional inheritance. So, as you said, right, it asked that question whether birthright citizenship bends to an executive order, and the court says no in the way that it does. But it is a disagreement about whether the Citizenship Clause is a rule that the 14th Amendment essentially inherited from common law, or is it domicile and allegiance? And we've been misunderstanding it the whole time. But again, for me, the interesting question isn't simply who has a better history, but what makes history legally authoritative in the first place. And so I'll just start with a couple of ideas about the majority opinion, and then toss it over to you, Edberto. I think that there's three distinct ideas in Robert's opinion. He does this kind of a codification thesis where the Citizenship Clause is declaratory rather than being innovative. It's declaring this pre-existing right from common law, and so Reconstruction wasn't an innovation. It was simply continuing along the line that we had already begun. He has this genealogy thesis, which I found very interesting in terms of how he structures the opinion, because what he's actually doing is he's arranging the sources into a narrative of legal descent, where he goes from the common law to this the Blackstone to Calvin's case. He moves through Dred Scott and Attorney General Bates, the Civil Rights Act, and finally gets to the 14th Amendment, and then talks about Wong Kim Ark. And so what I think is so interesting about that is that the sequencing is part of his argument. I think he's actually performing this historical interpretation through narrative form to persuade the reader about the justification for the majority's opinion. And then the final kind of distinct thing I saw coming out of Roberts' opinion was the methodological disagreement and kind of why Thomas and Alito reject Roberts's methodology in terms of what he's relying on. They're rejecting this genealogy that he's constructing, Thomas insisting that each historical source has to move independently and justify independently the decision that the court is making. So I found that discussion among the opinions to be really, really fascinating.
Yeah, I agree. There was a lot of interesting stuff in here, and it's almost a clinic in terms of interpretation, and almost a clinic in terms of what not to do if you're trying to support a particular kind of interpretative doctrine, like originalism, because the dissents, just kind of like, where did that go? One thing I did want to mention is the Dred Scott decision. It's something that we as lawyers and law professors, we know all about. We know, but it's not necessarily common knowledge for laypersons. I just want to mention what the court did there. It was basically two opinions, but the one that's relevant to this is the citizenship issue in Dred Scott. Dred Scott was a slave who sued for his freedom because he was taken to a northern state, the Illinois territory, where slavery was illegal. And he sued for his freedom when he was brought back to slave state Missouri. And essentially, the court said that he was not a citizen because he was an African, and that the Constitution did not recognize the citizenship of persons of African descent. That was in 1856. 10 years later, in 1866, the United States Congress, after the Civil War, passed the Civil Rights Act of 1866, essentially attempting to overrule Dred Scott decision on this point. You can't really overrule a constitutional decision with a statute. So they decided the best thing to do next would be to try to come up with an amendment. And that amendment was the 14th Amendment. And the 14th Amendment states at the very beginning that essentially persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. And that's basically an attempt, or it wasn't an attempt, it actually did overrule the Dred Scott decision. The issue appears to be a disagreement between the dissent and the majority as to what this subject to business means. And that's the problem. What as you mentioned, Laura, what Roberts did, and kudos to Roberts here, and mark this date down. I actually said something nice about Roberts. what Roberts did is he looked at the common law and followed it all the way back to 16th century England as to where this comes from. A term called jus soli, or jus soli, which basically means of the soil. Persons who are born of the soil are under the protection of the sovereign. And that's the old English common law understanding of this principle. It's a principle that traveled across the Atlantic to the colonies, to the United States, and had animated the citizenship of immigrants coming to the country before the Civil War for generations. It was changed by the Dred Scott decision, at least for Africans. The Congress decided in 1866 and later in 1868 with the amendment to overrule the Dred Scott decision, not just for blacks, but for everyone who met the criteria of birth in the United States. Now, Justice Thomas says, oh no, birthright citizenship applies only to Black people, the descendants of the enslaved persons. I guess that would include me.
Yeah, Laura and I are out.
Huh?
Right.
Laura and I are out.
and Justice Jackson challenged that.
Mm-hmm.
She challenged that. She points out some interesting things I was not even aware of. These series of what were in those days, against common language, colored people's conventions, where they actually were advocating, as the 14th Amendment was being considered, for a more inclusive U.S. Constitution, which would include not just the descendants of the enslaved Africans, but anyone born in this country. And whether they knew it or not, they were actually calling for the return of the common law doctrine to the Constitution. And that's what this case is really all about. Thomas wants to limit it to Black people, but the reality is that is a point that both Justice Roberts and Justice Jackson make, is that the common law does not have such a limitation. The common law is more general than that. So that's my spiel. I want to talk about Kavanaugh eventually, though, but I want to go ahead and get Eddie Berto's thoughts about this. What do you think about the?
Yeah, I mean, I agree with both of you with respect to the give and take. This is something that the nerd that I am in terms of my scholarship, I've been looking at this issue for decades, right? And I've done the deep dive. So I do appreciate how Roberts tried to stay true to the original jurisprudence and doctrine that the court is following, right? The majority of the court follows here. But I think it fell short, frankly. This is where I believe it fell short. In many respects, all right, the Barber v. Trump decision, and we should appreciate, we talked about it before in a previous podcast, the notion of Barber is a pseudonym for a series of families, right, of plaintiffs who might otherwise be viewed as undocumented, depending on how the Trump decision turned out, right? How the birthright. So this was a means to protect them in terms of the ACLU representation with respect to these efforts.
That was our first broadcast too.
Yes, and what I want us to appreciate that in many respects, this decision is the response, right, to Dred Scott. And it's not viewed that way, but in the way the various opinions, right, frame themselves, they actually address the issue that Dred Scott failed to thoroughly analyze, i.e., what does the Constitution mean? And as Eric Foner, the acclaimed historian, who are the we and we are the people, right? That famous reference that he made. And Roberts did a nice job of the common law, but he stopped there. And it baffles me a bit why, and I don't know if it was his clerks, and I have to be honest, this is a vanity point. A little annoyed with the editors at the University of Pennsylvania with an article that'll likely come out, any day now. It's supposedly in print on their Commons page. But more importantly, the whole goal of originalism is to determine what the drafters thought at the time. So I think part of that is the common law, but it's not all of it. And the drafters, as I address in a series of my writings, particularly my latest article, basically addressing birthright citizenship and the subject to the jurisdiction thereof clause of the 14th Amendment, because that is what I argue the revisionist effort to try to understand what right, the enacting Congress thought when it passed the 14th Amendment. And the revisionists here, which often are labeled, right, as the liberals, right, the intentionalists, the revisionists here are not the liberals on the court, all right, the minority, the three amigas, as I referred to in the past, now coupled with a fourth amiga and the Chief Justice. The revisionists are trying to use the language of subject to the jurisdiction thereof, right? And in a political, I believe, endeavor, to say that those, right, and this is where the allegiance points come in, those that are undocumented, that come into this country, and this is an argument that that is raised in the dissents, as well as, right, raised repeatedly by conservative scholars, many of which I've debated on this very point, to say that that was a condition on birthright citizenship. That if you essentially enter the country undocumented, you have no allegiance to this country, right? And through some perversion of an antiquated and arcane, right, anachronism, rightly so, of a notion known as corruption of the blood, that if your parents have no allegiance, then therefore you must suffer that same corruption or frailty or wrong associated with entering the country undocumented, and therefore you're undocumented because you don't, the argument, even from a logical standpoint, is stronger vis-a-vis the parents, if you accept the conservative view, and particularly the views of the dissent, that you have no allegiance because you came undocumented and you did not intend to follow law by virtue of your action. Although I don't think they phrase it that forgive my pride, artfully. But essentially, that's what they're arguing. And that somehow the children can have no allegiance, which doesn't make logical sense from a parental lineage standpoint, and a basic logical point of being subject to our laws. I.e., if you're undocumented, you still have to follow our laws and can be punished by our laws. And that's what it means to be subject to today. But guess what? It also meant that when the 14th Amendment was enacted, not one professor's view, which I exhaustively examined in a series of articles, and particularly my latest one, where I go through the enacting Congress, and they actually address these very issues, particularly in that context. And in a television interview I did earlier today, they address the issues of, at the time, which was the undocumented of the time, the Chinese, and the term, the inartful term of the Romani gypsies, as they described them, right? And I'm, a little troubled by a right person of that lineage or descent making references like that, but that's what they use in the congressional record. And the objection, particularly Senator Cowan, objected, much like the conservatives of today or advisors, right, to the president in signing the executive order, saying that citizenship was never complete, right, or absolute in terms of birthright citizenship. It always was only available to those that are subject to our laws. And that's a very argument raised by the Congress in enacting the 14th Amendment. And that argument was soundly rejected by a series of senators, including the ones, and this is very important, including the ones that, such as Senator Howard, among others, and Trumbull, those that promoted, right, proposed the enactment of the 14th Amendment. They rejected Cowan's request for a carve-out to say, hey, these undocumented people, and they didn't use that terminology, but these people, the Chinese, as well as the Romani gypsies, could not be citizens under our laws at the time, including the Chinese Exclusion Acts, right, in terms of this era. And the Senate that was examining the 14th Amendment, the senators, all of the senators proposing it, every single other one other than Cowan, rejected that carve-out. So where I find I was pleased, right, that from my perspective, the good guys won. It was true to the interpretation at the time and consistent with the logic and ethos of our country, right? That the 14th Amendment was a remedial measure to ensure this exclusionary vision of the Constitution and who could be citizens as identified by the Dred Scott decision would be rejected. So there is where I am troubled by the Roberts opinion. I find it fell a little short. And the dissents, in many respects, engaged in a political endeavor that wasn't even consistent with their jurisprudential benchmark of originalism. And I'm going to leave it there, and I have more to say, but I sense that Laura is itching in light of her nods, and I hope all of them are seen in terms of that. That was amusing. Please, Laura.
Well,
Yeah, you raised so many incredible points, and I was just tracking all along the way, right? Because you're bringing up the specifics of the history and this, and I agree with you, right? I like Robert's narratization of the history and kind of stringing along this idea of historical continuity. And I think it's fair, what you say, that it goes as far as it goes, but that he doesn't go all the way. But which is why I appreciate Justice Jackson's concurrence so much, right? Because she does lean in to that Eric Foner, second founding. The Reconstruction Amendments were anti-caste, anti-subordination, a second founding, a reset for the nation. It was not simply a narrow correction to the specific problem of slavery. And she goes and ties the clause's universal language to, as Craig brought up, the colored conventions, and rejects that narrow fought and bled account of political membership. And hers is ultimately, to me, as I read it, an argument about constitutional memory. And she's saying, look, nations have to have memories. And she warns against reconstructing the past in order to serve present political ends, which was
Excellent. I agree.
which was the sense I got from Justice Alito's opinion, which was like, well, we've got this massive problem now. It's like, well, you're not wrong, if you want to phrase it in that way. It's not the way, I would phrase it, but it's a valid point, or a fair point, if you want to raise it. But that's a political point. That is not an originalist methodological, what does the Citizenship Clause mean?
right.
And so half of his opinion is, I'm like, well, thank you, because if I didn't already know your political stance on this particular issue, I know it now. But it is irrelevant to the jurisprudential decision. And
Yeah.
and Jackson's closing move, in her opinion, I thought was especially interesting, that the Constitution's commitment to equal citizenship is race conscious in purpose, but it is universal in its application, right? And holding those ideas in it shouldn't be that hard, but it seems to be very hard for some people. And so I see Robert's opinion and her concurrence kind of working together, where he's explaining why the Citizenship Clause means what it does. And Jackson is explaining what kind of constitutional community that meaning creates.
I think
Yeah,
that Jackson's opening, she wrote it. A lot of people think that she wrote it to counter Thomas. I think there's a little bit of a rivalry going on there on the court, because Thomas really I thought, was insulting to her in the SFA, the Students for Fair Admissions case, and it wasn't even called for. Um, so I think she's kind of getting back at him, and she said this: "I join the court's opinion in full. I write separately to respond to some of the themes in the principal dissent. Despite his longstanding endorsement, this is the catcher right here. Despite his longstanding endorsement of a colorblind constitution, Justice Thomas now surprisingly suggests that the Citizenship Clause was a race-conscious remedial measure relating only to freed slaves, such as Dred Scott." Now, I don't know how Thomas can get around that, other than to go about and press this domicile issue for 60 of the 91 pages of his opinion, which is what he did essentially.
Yeah.
And I think Roberts answered that well. And to your point, Edilberto, um, Roberts points out some language by Trumbull when actually, and you did mention, but I just want to put an emphasis on this. When he was challenged about the possibility of certain people becoming citizens, he says essentially, enthusiastically, "Yep, that's right, exactly. The children of it will make citizens of the children of the Chinese and the Roma people
Right.
in this country." He said
Yeah.
that he was one the sponsor of the Civil Rights Act of
Yeah. Said,
1866.
I believe he said undoubtedly, right, responding to
Right.
Senator Cowan's concerns, and I'm glad they did that. I'm glad Robert said that. I just wish he would have gone further, right? It's like a B minus in my seminar, I hate to say.
Right.
You touch on it, but there was so much more, and there was so much depth. The lawyerly efforts that Thomas and Alito engage in are a bit sophomoric. And when someone engages in that, you should crush them. Forgive me, in terms of my Wall Street litigation training. When you have right the full quotes, when you have the exhaustive and unanimity,
Mhm.
absent one writing, and the only other thing they hang their hat on repeatedly is misquoting Trumbull and that reference. What does right? Jurisdiction mean? It means allegiance. But if you read the entire quote, it means allegiance mean having to follow all laws. And I just wish the opinion would have been stronger with respect to that. But I agree with both of your assessments. But here's one thing I captured out of it. I do think that Thomas engaged in an artful effort, well written, and I would have agreed with everything you said in terms of characterizing his opinion, except that last clause, only for African Americans or those of African descent. Because nowhere does the legislative history suggest that, nor does the common law suggest that at the time, which I go into in great depth in terms of a recent article that should be, again, much to my chagrin, published any day now. I've been saying that for months. But so I think they didn't go far enough in terms of the majority. I wish it would have been a little bit more persuasive in terms of pointing out how it was unequivocal, there was unanimity with exception to the one dissenter. And when that outspoken soul, much like today, right, spoke out, resoundingly rejected and explicitly rejected. And that's kind of lost a bit in the opinion in terms of how clear the legislative history was, as well as the common law, because I think the domiciliary argument stems from right Juan Kim Mark that we've heard before, and again they misinterpret Juan Kim Mark by looking at the last paragraph in the holding, not appreciating that the entire decision
Yeah.
was
Yeah.
not rested on the notion of domiciliary, right? The domicile of the applicant. That's not what the decision about. It was basically a thesis or synopsis of where the case was in its factual setting, but
Exactly.
not the basis of the analysis. So that's one rhetorical device that I expected, and we saw in Alito in particular, and Thomas to a lesser extent. But I thought Thomas was a little bit more artful and lawyerly, not very good in terms of being lawyerly, in terms of the effort, because he had to hang his hat on something, right? The allegiance point that I alluded to earlier doesn't make sense for the reasons I alluded to. This domicile argument doesn't make sense if you actually read the opinions. And mind you, almost a dozen opinions of the United States Supreme Court over the course of a century, right, interpreting Juan Kim Mark, as well as the 14th Amendment itself, that reject that view. So that domicile argument, doesn't hold water in light of Juan Kim Mark itself, as well as its progeny. This notion I thought was fairly novel and fairly new, that we haven't seen much of 14th Amendment only being for African Americans, because doing so gives us the modern day, right, what I would say, not originalists, right, intentionalist efforts by the conservatives, right, to find loopholes and find additional. I think that's in part why Kavanaugh kept on saying repeatedly the 4 exceptions. I don't view them as 4. I find 2 without question, and arguably a third made in passing reference, enemy combatants. It wasn't the focus of the 14th Amendment, but it was in reference to the common law and to a lesser extent, the Civil Rights Act of that era. So it gives them the opportunity to be revisionist, or as they would say, true intentionalists, to a narrow reading of the 14th Amendment, which wasn't the case. And the last point I wanted to make is I thought Jackson's opinion was kind of exciting as, and I'm going to say a curse word here, in Florida at least, to a critical race theorist like myself, right? And that's a curse word, by the way. I'm not going to use profanity. Yeah, I have my colleagues concerned there. This notion of, and I've written about this in terms of how this notion of a colorblind society stemming from MLK and others, as well as I would dare to say Justice Harlan's dissent, right, of over a century ago with respect to Plessy, in terms of these issues. Notion of a colorblind society wasn't made to make us exclusionary. The notion when the great iconic prophetic, right, Dr. Reverend Martin Luther King spoke about it. He spoke about inclusivity, right? An inclusive country, an inclusive constitution. And I think Jackson was personifying that as a critical race opinion. And the beauty of it, she had the originalist, right, interpretation absolutely correct with respect. But she too, the nerd that I am, I would have liked her, right? And I'd probably blame her clerks more than anyone else, push them further to appreciate that in the 1860s, our political leaders were much more inclusive than many, or at least 3, arguably 4, of the justices and many politicians, and certainly leaders in the executive branch, want to interpret the Constitution as an exclusionary model. So I'm happy with the results. I thought it could have been stronger, and I take issue with doing kind of incomplete homework on the effort.
I want to, along those same lines, because this is something that I was elated when I saw the opinion. We were talking on the phone, Eddie Burt and I, when the opinion came down. I was refreshing, and then it finally came down, and I was elated for hours. I mean, I didn't watch the news all day, and then because I was busy reading the case, that's a lot of pages to read, and what I finally found out when I turned on the news is that Kavanaugh's opinion has given a little bit of encouragement to the other side here. For some reason, Kavanaugh thinks that you can pass legislation to undo a constitutional opinion. Now, this to give the background. Kavanaugh says that the latest version of the Immigration and Nationality Act, which has language which is almost identical to the actual language of the amendment, could be amended, or Congress could pass a new law that grants additional exceptions to the birthright citizenship principle. How does that happen? I mean, the Congress of 1866 realized you can't just pass the Civil Rights Act of 1866 to overturn Dred Scott. You can't just do that. You have to do an amendment. So now Kavanaugh is talking about passing a law to basically overturn a decision of a constitutional decision of the Supreme Court. He says Congress could, consistent with the 14th Amendment, amend 1401, that's the portion of the statute that we're talking about, or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country, but Congress has not yet done so. What am I missing?
Yeah,
okay,
well,
Oh,
Yeah,
oh,
please, Laura.
okay, you're right. So, because I'm hoping that what I say is going to give you fodder to take this and run with it. Kavanaugh, I just want to say his. You mentioned early on just about there being just some confusion about what he's trying to actually, the point he's trying to actually get across. And so the paragraph that got me was where he says, Wong Kim Ark's treatment of the exceptions as a closed set is incorrect. And here we go. Considering the four exceptions as a permanently frozen or closed set as of the 14th Amendment's ratification in 1868, such that there can be no subsequent exceptions recognized based on new developments after 1868, is inconsistent with the court's longstanding approach to constitutional interpretation in a variety of areas. Originalists rolling over in their graves, right? Because I'm just going, I'm sorry, what? And then he goes on, and so then he tries to pull from the US versus Rahimi decision, where the court's own history and tradition methodology came back and put them in a corner, such that Roberts had to, in that gun regulation case, say, oh, no, 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 we're not looking for historical twins. We're looking for, like an analogy, some kind of principle that we can pull forward. And so Kavanaugh starts talking about analogies and analogizing to the way the court developed new technology, application of the Fourth Amendment, and the First Amendment covers internet, and I'm like, that's not the same thing. That's not what's going on here. And so his entire approach methodologically reads to me like he is leaning in to living constitutionalism in a way that I'm not sure he's understanding what he's doing.
Yeah, I agree. And I have two views, maybe three, in terms of what Kavanaugh was trying to do, because it's hard to, other than the words being used, try to go into their mindset. One is somewhat forgiving and suggests a sleight of hand, politically motivated sleight of hand. The other is flat out to state that the opinion is profoundly ignorant. And I'm not sure which it is, frankly, in light of a lack of logic. So if I'm gonna give the more forgiving interpretation, I think what Kavanaugh is doing is suggesting that subject to the jurisdiction thereof language of the 14th Amendment by the enactors was a set of exceptions that they left open, right, in light of what they were dealing with. And by not closing off others, right, that it's kind of a post hoc rationalization, it leaves room for addressing, much like an intentionalist, right, or a living constitution devotee, which he is not, right, normally would argue for. It leaves room for addressing issues that weren't addressed at the time. That's one read of it. Problem there, again, this is not a B- paper. It's probably C-, and you're going to have to take the course again if you're in my class in terms of a senior thesis, because it doesn't cut the grade. That's not what the 39th Congress thought at the time and addressed at the time. They addressed the exception proposed, right, by Senator Cowan and no one else in terms of trying to add, can't we expand, right, the exceptions that Cowan specifically said, other than diplomats and the indigenous people, that were the two carve-outs that the 39th Congress examined at the time. And the proponents, right, of the sponsors of the enactment of the 14th Amendment rejected that, explicitly. And my dear colleague Craig a moment ago made reference to what Trumbull said with respect, as well as Senator Howard, that said that these individuals, this is exactly what we mean, that children of these individuals would be U.S. citizens. So there wasn't this open-ended carve-out of subject to the jurisdiction thereof, and therefore we can add perhaps some in the future. And using a jurisprudential, movement, right, or theory that's wholly inconsistent what Kavanaugh has historically stood for in terms of originalism. So that makes no sense, and it's inconsistent with what the enacting Congress, and that's why I'm troubled by the majority not explicitly going a deep dive into what the enacting Congress wanted and stated in terms of that issue. So that's one reason, to give them the political maneuvering to address issues that Congress didn't address and perhaps left open to be addressed. That's the only one that makes somewhat sense, but it's inconsistent with his philosophy. The other one is just a misguided notion of the doctrine of constitutional avoidance, that says if the issue can be resolved by not getting to the constitutional question, by looking at a statute, right, enacted by Congress, we should do that. The problem here is that the statute he's referring to is explicitly quoting the 14th. There's no difference. There is no additional right or exclusion created by the statute. And he is suggesting that a statute can basically overturn a constitutional amendment. And it makes no sense. A statute can provide more rights, right? If the constitutional provision provides only a limited number of rights, a given statute, being state or federal, can provide more rights as long as it's not inconsistent with a congressional opinion, but it can't basically rewrite the Constitution. He is doing by statute what President Trump tried to do with the executive order. And I'll leave it there because I sense that Greg is itching.
The exceptions that you talk about, I don't think what Kavanaugh understood was that those exceptions really have to have a basis in international law, such as ambassadors, enemy occupiers. And that's what Trumbull and Howard were talking about during the 1860s. That international law, so you cannot have the jurisdiction over an ambassador or any diplomat. That's kind of a comity, a concept in international law. Same thing with enemy occupiers.
Explicitly addressed it. That's not.
Yeah.
Look at the
or as they called it back in those days, law of nations, essentially. So basically, that's what that is an allusion to, and he doesn't quite seem to get that. Those aren't just exceptions that are pulled out of the hat, out of thin air. Those are exceptions that had a grounding in international law that they had to include in the consideration. And I think that's what the court in Wong Kim Ark is talking about as well when they acknowledge those exceptions. But
nothing in the legislative history or Wong Kim Ark suggested there was an open-ended grouping, right, that would be expanded upon. That was actually what was requested, right, by a dissenter of proponents of the 14th Amendment, and that was rejected. And I think Kavanaugh is trying to provide a living document kind of argument, right, that's inconsistent with his otherwise judicial philosophy to provide future exceptions. And one of the things we should appreciate is that there are options, and it's called the constitutional amendment process, right? Not to have a president just by, executive fiat, right, change the Constitution. But everyone knows that process is a long and arduous one. The other effort that I think undercuts deeply Alito's, again, living document argument of the contemporary issue, including birth tourism, is that because there is birthright citizenship, and you two may disagree with me, it does not stop the executive branch from passing certain laws pertaining to attainment of visa, i.e., if a visa is being attained by virtue of fraud, right, instead of tourism or instead of educational-based visa, right, or employment-based visa, for the sole purpose of to enter the country to have a child to get birthright citizenship, that's inconsistent, right, with our regulatory framework and could be a basis that falls short of the constitutional challenge. And from my perspective, perfectly appropriate. Your thoughts?
Well, Laura, you got anything on that?
Well, I was going to talk a little bit about Alito's carve out, but go ahead and I'll come back to the carve out.
Well, it seems to me that if you go that route, so you're basically making it harder for people who are attempting to get a visa to take it to benefit from the Birthright Citizenship Clause, make it harder for persons who are seeking to get a visa to take advantage of the Birthright Citizenship Clause than it is for persons who are coming into the country legally and having children. I don't know. I would just assume um, both categories would benefit from the birthright citizenship principle.
Yeah, the only difference is the current framework says if it basically the border protection, right, efforts that basically state if the sole purpose is for birthright citizenship, that's a grounds for denial. We can enforce, right, a regulatory framework that provides basis that is consistent with our ethos of be it humanitarian, family family based, or economic based. And if your sole purpose is something other, because right now we have for tourism, right, among others, education and business related, right, providing certain provisos in each. Now, if your basis is to use birth tourism to circumvent, right, these efforts to allow the child for their educational purposes, or yours 20 some odd years later, right, for them to bring you aboard, that seems to be inconsistent from a regulatory standpoint that you don't have to get to the birthright citizenship issue. All right.
Okay.
And some that are more open borders with respect to that, right? My view may be more conservative, but I don't see anything wrong from a regulatory standpoint to say if you're coming solely for the purpose, and that was my television interview today, right? That there are entities right now that are basically advertising to provide a means for birthright citizenship, birth tourism, right? Efforts. The concierge service, Miami Concierge Service, is one that's referred to in that interview that evidently provided that as a selling point and at exorbitant prices from $20,000 to $100,000 to have your child become a U.S. citizen. So I think a regulatory framework can address the issues, may not be something that a bit more, should I say, open border or progressives may agree with, but I do think we have to have a framework that is consistent with our basic immigration goals or the pillars of it that doesn't conflate the birthright citizenship issue.
Yeah, and I think that hopefully leads into what I was going to say, because you know he does, mention Alito. He does mention kind of the development of the immigration issue, and the challenges of getting bipartisan support for any kind of regulatory reform that would address substantively the issues. But his reliance on his theoretical development and it just doesn't hold water for me, because he gives this carve out for individuals who have been here for a long time, right? But while I agree that people who have been here need a path to citizenship, his carve out doesn't obviously follow from the theory that he builds in terms of his opinion, right? He's got this allegiance theory, and one that doesn't clearly resolve dual citizenship problems. It just completely elides that. And then his refusal to strip citizenship from those already born to like long settled unlawful immigrants seems to rest more on equitable judgment than on the logic of his own constitutional theory, right? His own constitutional, theory. And so that tension, I think, is worth sitting with directly, because it resembles precisely the kind of pragmatic adjustment that originalists criticize everywhere else. And it's just, you can't have it both ways. And so that was one of the troubling things I got from his opinion.
Yeah, unless you're selectively principled, right? A thing
Yeah.
that we repeatedly alluded to.
Right.
Yeah, a friend of mine texted me, or actually commented on one of my Facebook posts. How can textualists object to the interpretation of the Birthright Citizenship Clause. And my response to my correspondent was textualists and originalists, they only follow originalism and textualism when it suits their means.
Yeah, yeah, yeah. That's what it seems to be. And that was a question we posed in I believe, our very first podcast. The question would be whether the jurists would be jurists or politicians. Mm-hmm. They all answered that, right, with 5, right? Including the 3 amigas and Chief Justice and Justice Barrett. My prediction, I was off on Gorsuch, and I'm very disappointed in him. Given his sensitivity to the issues with the territorial people and its recognition of citizenship and inclusion, I'm a bit baffled. I mean, maybe clerks are not the researchers that I once believed they were, because I don't see it. I don't see their basis, their grounding. It's inconsistent with their jurisprudential views, their philosophy. It's inconsistent with the evidence. It's inconsistent with the legislative history. It's inconsistent with the common law history. It's inconsistent with a host of Supreme Court decisions on these very points. So are they politicians? Well, it strikes me 4 are close to being it, where one of the 4, right, a bit confusing. But this is not the first time, and we mentioned it, Craig, excuse me, right before the podcast when we spoke about it earlier today. When I reminded you of Vasquez Perdomo opinion, his concurrence in that, which made no sense. He sought to overturn a century, right, of what we call criminal procedure, which I would more perhaps accurately refer to as constitutional criminal law. He, with a stroke of a pen, he just wanted to rewrite everything that basically says, probable cause is speaking Spanish. And fortunately, shortly thereafter, he backtracked, and that's gonna, that folly will be something he would like to forget, among other things in his past.
Yeah, of course. Probable cause is speaking Spanish. That was terrible from last year. So listen, one other thing about the opinion is they use a lot of history, and sometimes when you use history as an originalist as an originalist, and Thomas even uses the term original public meaning in his dissent, you have to go back and look at what people said. Oftentimes, what people said are what senators said in debates. That's getting awfully close to legislative history right there, which is supposed to be an anathema to the conservatives these days.
Well, I'm going to be quoted here as saying something nice, and since you said I forget who it was you referred to, I think it was Roberts, the nice thing. I'm not sure these conservatives have the gravitas of Scalia. Scalia, when he went after, the intentionalists, was scathing and brilliant, frankly. Those who are advocates of a variety of positions or stances know their weak points, and Scalia would know it. And Scalia didn't mince words with his rejection of legislative history. Right. I think that would have been stronger footing, but because they are not as strong, even though Scalia wasn't always consistent in that position, by the way, but at least in his vehement dissents and a majority opinions on this, it was, at first blush, a stronger position. But these folks seem to pick and choose when they want originalism, and it doesn't stand on as strong footing.
Yeah, I'm sorry. Go ahead. I was going to say, I absolutely agree with you. And the other thing I think to remember is that these justices are writing at different times. Scalia is writing in the heyday of originalism as a critique to the New Deal and the Warren Court decisions. He is all about pointing out where the weaknesses are and the vulnerabilities are in the Warren Court's rationale and justifications. These justices, now that we are all originalists now, are having to write from a positionality of, okay, prescriptively, what do you recommend? Like, how do we develop this? What is the doctrinal test? How do lower courts apply these pronouncements that you're making? It's no longer just sitting in the back row and critiquing. You've got to come up with, using your historical method, using the evidence, you've got to come up with some kind of prescriptive theoretical approach. And they're failing.
Yeah, judges are notoriously bad historians.
I'm sorry?
And that's what the professional historians say this all the time. The judges are just notoriously bad historians,
Mm-hmm.
and they don't know historical method. They don't know how to use it, and all they can do is really quote quote actual historians, and then it gets into the job of picking and choosing. There were conflicting historical briefs submitted. Say, for example, in the epitome of I think of originalism, I think the Heller case, the Second Amendment case, there were conflicting historical documents. I mean, briefs, amicus briefs that were submitted. It just shows that history, even among the historians themselves, are not necessarily consistent. How can judges be consistent on history when they're not trained to do that? That's
Right.
yeah,
Yeah.
it's crazy.
And that's a forceful critique, right? That we're using against the conservatives here, but it's one that could be used against the liberals in other settings. Yeah, that's what makes Scalia so powerful in his critique, even though he doesn't always apply it in his opinions. And if I may, for a moment, I wanted to refer to a former colleague who has since passed, a professor by the name of Steve Plass. He wrote a fantastic piece decades ago that was referred to as the allure of textualism, where he took on Scalia and his critique. But it reminds me of the point you made, Craig, about how Thomas and others are playing fast and loose with legislative history. At least Scalia in his pronouncements, right, was fairly consistent, not always in his application.
Well, Scalia said, "I'm a textualist, but I'm not a nut." So
Yeah.
even he admitted that sometimes you have to watch it. Well, we've spent an hour talking about this. This has been a very good session. You know, it comes the week of the 250th anniversary of the country, and I just wanted to offer up a closing statement, and anyone else wants to join in, feel free. Um, what is patriotism, and do these cases mean to us as Americans? And how do we look at our 250th anniversary in light of this case, but at the same time in light of the TPS case? Um, how do we digest that on this anniversary of our country? And the thing is with me is that I'm not a big fan of the traditional uh, emotional patriotism, greatest country on earth type stuff. But I do consider myself a patriot. My father was a Nazi fighter. My grandfathers were both. My grandfathers both fought the Kaiser. And as far as I'm concerned, what makes the country great is how the country keeps trying to get better, even when it goes back, which is what we're doing right now, unfortunately. But I'm not one to trust my father's legacy and my grandfather's legacies to people who didn't respect them, whose patriotism would not have respected the 761st uh, tank company, all black tank company there in Patton's army in World War II that my father was in, or the doughboys, the black doughboys that my grandfathers were part of, who fought the Kaiser. I'm not going to cede my patriotism to those people who don't respect them. And currently, we're seeing a lot of that right now. So I
Yeah.
celebrate the anniversary, the sesquicentennial, I think so. Whatever, 250th anniversary. I celebrate that as American in my way, for my father, for my grandfathers.
Yeah, I appreciate that. I want to thank them for to you on behalf of them and many others for their service in terms of it. And for me, what you said reminded me of the power and beauty of this country. that, in so many other countries, and this is where I may be more conservative than you two, I haven't asked you about it, the recent political references and the trendy, including perhaps views held by our editor of the Democratic Socialists, right? Labels. In so many other countries, what we do here, right, would subject us, perhaps rightly so here, to ridicule or debate, but not, to our well-being. And that's what's, for me, the power and beauty of this country. I think pretty directly said, Alito was trying to be a politician. I mean, excuse me, Kavanaugh was trying to be a politician or a buffoon, in that opinion. And, without perhaps naively so, serious concern for my life. In so many other countries, we don't have that privilege. And for the opportunity, right, to have Justice Jackson, Sotomayor, among a host of others, right, in the past, no matter what your bent is or perspective. I'm no less a proud American because I'm critical of it, right? It reminds me of James Baldwin's references, because he loves his country so profoundly that he will incessantly criticize it. But I think, implicit in that, with the goal to make it a better country. So I think that's the beauty and power of this land.
Well, happy July 4th, everyone. And we will and stay tuned to this space. We will be talking about the other cases. There are some big ones. The TPS case I mentioned in passing this, and we didn't get a chance to talk about, but we're going to talk about it in future episodes. And the remainder of the final major cases that came out this week and last week. Stay tuned for that. Thank you for viewing us. We're on YouTube these days, and enjoy your week.